What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we are going to talk about another motion in the Karen Reed case. This is a motion for reconsideration filed by the defense regarding Dr. Crosby, the Commonwealth's dog bite expert. And if you remember this order from the court, this was the one that I felt like was the easiest call for bias for Judge Cannone, because we were comparing apples to apples with how she handled the Dr. Russell situation, with how she handled the doctor but not MD Crosby situation. And now she has an opportunity to fix that, because it's not that she let Crosby in that I found or that I took issue with. It was the way she did it. And the defense filing this motion gives her an opportunity to do the right thing. Will she do it? I'll give you my thoughts after we read the motion. And we are going to read through this bombshell statement made by Michael Proctor's family that people said, just wait till today. Everything's going to change in the Karen Reed case. And we will talk about that as well after we get it through the motion for reconsideration. And make sure you guys hit that like button and are subscribed to our page. Let's get to it. All right, here we go with page one of the motion. Now comes the defendant, Karen Reed, and respectfully requests that this court reconsider its March 6, 2025 court order, March 6 order, denying defendant's motion to exclude the testimony of the Commonwealth's witness, James W. Crosby, MS, PhD, hereinafter Dr. Crosby, not MD. And after such reconsideration, defendant requests that the court exclude the entirety of the proffered testimony of Dr. Crosby. In the alternative, and at a minimum, the defendant requests an evidentiary hearing to determine whether the Commonwealth can meet its burden to satisfy the requirements of Daubert-Lanigan as regards to Dr. Crosby. The defense could complete its questioning of Dr. Crosby in approximately 1/2 day of a hearing. So if you remember, one of the big issues with what happened with Dr. Russell versus Dr. Crosby is there were multiple days of questioning back and forth with Dr. Russell. The defense has to pay for that. Now the Commonwealth can say you paid Dr. Russell all this money, which includes the voir dire, which the defense is trying to get that cut from the experts, but it happened prior, and it did not happen with Dr. Crosby. So there's a number of things the defense could try to get here. Number one is obviously get Dr. Crosby struck. Number two, have an evidentiary hearing. Get the opportunity, basically at a free shot, a free deposition with Dr. Crosby. But more importantly, in that voir dire, they would be able to get into and highlight the fact that there is a major lack of methodology that he cites. They can try to figure out what articles he actually relied on, because based on his report, they don't know. He just cited to a bunch and said, I may have relied on some of these, which just is not good enough. And then number three, and that is to get Judge Cannone to put specific findings in an order, similar to how she did with Dr. Russell, but it doesn't even need to go that deep. She doesn't need to hit every problem with an expert. But what is the methodology that Dr. Crosby used? Why does she find that it's reliable? How does she find that it is seen in the scientific community? And why did she make the decision why is this not a close call? Basically, put that in an order. We've had situations like this come up in the past. We have had experts who have been, I've never had an expert completely struck, but I've had experts who are partially struck, or certain things that they've said, we've had to tailor out. And the judge said they can't testify to this, they can testify to that. We had overlapping experts where only one expert could testify to this, one expert can testify to that. And we have filed motions for reconsideration for judges to give us specific findings. So if we have an issue with it, we can appeal it. And so that we know, and we're all on the same page, and the experts all know, and the lawyers all know what to expect in this testimony. So that is also something they could be getting or trying to get with this motion for reconsideration, is just more specific findings from Judge Cannone that they could either take issue with later or at least know how they're going to go forward during trial number two. The court's March 6th order in denying the defendant's motion to exclude the proffered testimony of Dr. Crosby, the court stated in its March 6th order that the Commonwealth has satisfied the foundational requirements of Daubert-Lanigan. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. There is an appropriate basis for his opinion on the record, and the proposed testimony, principles, and methods are reliable. The defendant's objection goes to the weight of the evidence, not its admissibility. The court did not provide any record citation or other record evidence for how the Commonwealth has met its burden to satisfy the 5 foundational requirements, including prominently the methods are reliable requirement. So this is the indication that at the very least, They want more specific findings from Judge Cannone. Nor did the court address the alternative request of the defendant that a Daubert-Lanigan hearing be held should the court not exclude Dr. Crosby outright on the papers. Because again, if you remember in the initial defense motion, they said, we want you to strike him, but if you don't strike him, we at least want a Daubert hearing. The March 6th order contrasts with the court-ordered 2-day, and here's where they go, right? Which we talked a ton about this. It's where a lot of the heat came, where people say, now I'm biased because I think there's a biased order out there, even though I said, I hope Judge Cannone does the right thing on future decisions that she has. She has an opportunity to do that here and set the record straight, as I hope that she does. But of course, this is where a lot of the flack came from, because I just, in my opinion, called a spade, and I have not met a lawyer in real life who has talked to me about this stuff that doesn't 100% completely agree with that analysis, because a lot of it came out when that started blowing up a little bit on social media. But he's going to compare those orders here. The March 6th order contrasts with the court-ordered 2-day evidentiary hearing of Dr. Marie Russell, a medical doctor with approximately 30 years of experience as an emergency medicine physician and forensic pathologist. Dr. Russell co-authored peer-reviewed books on dog-inflicted wounds on humans and submitted an 11-page report before the hearing in which she documented her pattern recognition methodology with robust citations to peer-reviewed studies and articles that appeared in 27 footnotes throughout her report. And they left off one thing, if I may add, if I may, step on somebody's toes and say, and she was already found to be an expert by this court in a trial in this jurisdiction, which was trial number 1 in this case, right? We started from that point with Dr. Russell. Arguments were already made to strike her, and this judge determined that she can testify about this exact subject matter. Yet we had to go through 2 days of voir dire, multiple arguments, and a multiple-page order with the judge pointing out the potential flaws and stronger points on cross-examination for Dr. Russell. And that contrast in the orders between Russell and Crosby is really what I had a problem with. Not that she allowed them both in. I kind of figured that would be the case, even though everybody said, no way, never going to let Crosby in. I didn't see it going that way. Doesn't make me some savant or genius. It's just kind of how judges deal with experts in most cases like this, especially Commonwealth experts. It's very hard to get a government expert struck. In federal court one time, I had and I think I've referenced this before, a Daubert hearing where I questioned this proposed expert from Washington, D.C., who flew down to Tampa to be an expert in this case. And it was just not good. His methodology was not good. It was not properly peer-reviewed. And even in that case, the judge let him testify to certain definitions and meanings and what the purpose of posting certain things online was, but she cut out about 90% of his testimony. But she still didn't strike the government witness completely. And I love that judge, and she was very fair. She's tough, but she's fair. And we lost that trial, by the way, even with a very fair judge. It happens in criminal cases. Frankly, most of the time in federal cases. Jennifer Manning, how come she needs a voir dire, the most experienced woman in the world, but not Crosby? So if I want to play devil's advocate, it's not like dog bites are actually Dr. Russell's number one expertise. She is an expert. She probably has about as much background and education expertise as you can dealing with this as a cop, as a pathologist, as an ER doctor, dealing with car accidents, dog bites. She's got an extensive history, but it is an unusual expertise. So the voir dire doesn't necessarily bother me. And Judge Cannone's opinion at the end, allowing her in, doesn't bother me. Now, the shots she took and had to spell out what they could use on cross was too much, in my opinion. But I don't take issue that she needed a Daubert hearing. The fact that she didn't need one for Crosby is the bigger issue. Dubra, Peter, thank you for all you do. Do you think Judge Cannone will reconsider based on all her past rulings? So this is kind of going to be what I'll save this question. I'll answer it at the end. I'm gonna leave it up here and I'll bring it back up at the end. Only a higher court could force Bev to be fair. I think that she has made fair decisions at times in this case. She has. I do think that she has, and I hope that she does here. I agree with the defense on this, but do you see any risk with the filing? With her level of distaste towards the defense, could she double down and toss both dog bite experts? No. No way is this going to make her rescind her ruling on Dr. Russell. I don't think they have any fear about this. I kind of mentioned this throughout the first trial, which was my issue with them saying, you didn't give me an opportunity to object to the mistrial. This defense team is not scared to do what's right for their client. They're not scared to step up and zealously fight for their client, which every lawyer should do. You shouldn't be a lawyer if you can't do it. You shouldn't be a lawyer if you're scared of how a judge is going to react to a motion. So I don't think they have any of that in them. Allison Becca, what appeals or remedies does the defense have? Oh, there's So many. I mean, they can appeal all the different judicial decisions. They can appeal anything that goes wrong in this trial that we're still going to have to see. The list is so long that if we need to get there and if there's a conviction, we'll talk about this a lot after the trial. Nina said, so can the ARCA guys now testify about the wounds? That is definitely something that I would push with this judge. And maybe they can't testify about dog bite wounds, but maybe they can testify that this did not happen from a car. Because that's, I think, more within their expertise, even way more than Dr. Crosby, in my opinion. I would try to push that if I was the defense. I don't know if they will. The other thing is, usually you can't have multiple experts testify about the same thing. So if Russell's going to testify about it, you can't have Russell and Wolf testify about it. But if Russell's sticking to dog bites, maybe Wolf can talk about car accidents. If Russell's going to handle dog bites and car accidents, whether or not they could make those wounds, then she should probably be the one to do it and not Wolf and Rentschler. But it depends on the jurisdiction. Here in Florida, only one expert per specialty, which is why Rentschler and Wolf had to testify to two different things. If you remember, they went through that. So I think it's the same there. All right, let's keep reading. The instant motion for reconsideration. The defendant does not waive any and reserves all of the basis for the exclusion of Dr. Crosby as stated in her original exclusion motion. So basically what they're saying is, we know we lost that before. We're going to make some different arguments for some alternative remedies, but we're not waiving anything we said before. We still stand by that. Yet for efficiency, in this reconsideration motion, the defendant focuses on factor 4 set forth in Polk, namely that the theory underlying the opinion is reliable. This factor is also known as in the Daubert-Lanigan parlance as the methodology prong. A failure of any one of the 5 foundational factors set forth in Polk compels exclusion of the proffered testimony at issue. So we don't have to strike all 5. We just have to strike one. That's what the defense is saying here. But for the Commonwealth, they're saying we did do all 5. We hit all 5. We're perfectly fine. You didn't strike any of them. The Commonwealth's opposition to the defendant's exclusion motion. So now they're going to cite the Commonwealth's own argument against them. They're like, this is what they argued against Dr. Russell, so let's turn it around on them and use it on Dr. Crosby. The Commonwealth had 4 opportunities to show that it can meet the Daubert-Lanigan methodology prongs. Its written opposition dated February 17th, the supplemental report of Dr. Crosby dated February 19th, in which he discussed the mold aspect of his unsupported mold measurement methodology, but failed to account for the absence of any requisite overlay in his methodology. Oral argument on the exclusion motion on March 4th, 2025, and the list of cases in which Dr. Crosby has testified in court, which was submitted to the court on March 6th. In each of the opportunities, the Commonwealth failed to even attempt to show that the purported mold measurement methodology employed by Dr. Crosby in opining on whether the wounds to the right arm of the decedent were caused by a dog bite or dog attack is generally accepted in the relevant medical or scientific community, or that his methodology meets the apt Daubert-Lanigan factors. So basically saying they didn't even try to tell us that this is scientifically accepted methodology. K-Wag said, people saying mass lawyers agree with the Commonwealth isn't a flex considering how corrupt the system seems. Keep being used. So I will tell you, I've had lawyers reach out to me from Massachusetts and let me know how they feel. So I have spoken to multiple lawyers from Massachusetts, none of them handling the defense on this case. So before anything gets going with that. So I'm fine with, and I would be fine if a lawyer called me and disagreed. I'd love to have that conversation with them and they could be like, you're looking too into it, or you're too into this case because that's just a judge giving a bland order and judges do that. And frankly, if that was the answer, okay, I can understand that. If they're like, nah, judges give bland orders like this all the time. Sometimes they're more fired up about an expert than others. But at the end of the day, she let both experts in, and you know that's what happens a lot. And I would say, okay, I feel that. I get where you're coming from. Notably, Dr. Crosby, which again has not happened to me yet. Notably, Dr. Crosby has never attempted to make such a showing. Either his report is completely bereft of even mentioning of satisfaction of general acceptance of his mold measurement methodology or satisfaction of the Daubert-Lanigan factors, let alone a showing of meeting them. And he has never submitted an affidavit to support anything about himself, including his qualifications or documentation of any kind of how his purported methodology is generally accepted or otherwise reliable with citations to medical or scientific literature. On February 17th, the affidavit submitted by Mr. Brennan is likewise of no weight in the inquiry, as he lacks firsthand knowledge or the requisite expertise in the subject matter of dispute. But even in his affidavit, Mr. Brennan mentions nothing about the satisfaction of the common acceptance precept or the Daubert-Lanigan factors. Tellingly, Mr. Brennan merely states in paragraph 7 in a bald conclusion that Dr. Crosby has engaged in substantial methodology. Substantial does not begin to satisfy the requirement that the mold measurement methodology of Dr. Crosby is supported by evidence of common acceptance in the relevant medical or scientific community or satisfaction of the relevant Daubert-Lanigan factors. Likewise, in its written opposition, the Commonwealth stated that Dr. Crosby engaged in recognized methodology to study the abrasions on John O'Keefe's arm, but wholly failed to state any source for such recognition. As a result, the Commonwealth has provided the court with no basis on which to conclude that the mold measurement methodology of Dr. Crosby is reliable. The prerequisite for satisfying the fourth factor of Polk, the methodology prong of Daubert-Lanigan. The court cannot satisfy its gatekeeping function by invoking the same conclusory statements as the Commonwealth has invoked here regarding a reliable methodology. So basically, a rubber stamp will not fly here. Should have been more specific. If the judge doesn't allow the evidentiary hearing, what appeals or remedies does the defense have? Well, they could say that she let in an expert that was clearly not qualified, that this expert should not have been allowed in based on Daubert-Lanigan, and the fact that she let this expert in, he was way too important in convicting Karen Reed, if that's what ends up happening in the end. And without this expert, they would have lost, or at least it was a negative effect on Karen Reed. So that's what they would have to argue at the appeals level. Will they bring Chloe in? I doubt it. I doubt it. Fanning and Crawford had a company which handled all the CW videos, hired by CW. They got caught altering videos in another trial, closed the company. Well, isn't that interesting, Nina? Isn't that very interesting? Oh, by the way, I didn't mention that. I'll mention it in a second when I switch documents here. The gatekeeping function of the court under Rule 702 and its importance. So before we get here, actually, let's take a break here for an ad, which is my favorite sleep aid that a lot of you guys got and you told me about that you got. So if you do try it, let me know what your favorite flavor is and how it works for you, because I really do love Beam. In order to work really hard and get a lot of things accomplished every single day, you have to sleep well. And when I got introduced to Dream, that became so much easier. Dream helps you fall asleep, stay asleep longer, and wake up refreshed without grogginess. To me, it's not that difficult to fall asleep. Sometimes my wife says I fall asleep in the middle of our conversation, but staying asleep sometimes can be difficult. And if I take anything to fall asleep, I usually wake up a little groggy. Dream is different. That just doesn't happen, which I love so much about it. And I'm thankful that they're sponsoring this video today. Dream is a revolutionary approach to sleep with natural sleep supportive ingredients in the form of guilt-free, indulgent hot chocolate. They say hot chocolate. I kind of like it cold. The cold glass of chocolate milk is how I mix it up when I take Beam at night. And there's no added sugar, only 15 calories, gluten-free, dairy-free, vegan, non-GMO, keto-friendly. So get the sleep you deserve with up to 35% off Dream. Just click shopbeam.com/Peter Tragos and use code LYK at checkout. 35% off for something that'll help your sleep incredibly. Code LYK. So you can get a good night's sleep too. All right. So I saw some people putting in what their favorite flavors are. I love it. We'll talk more about it later. Okay. Case law makes clear that the gatekeeping function of the trial court is especially significant. This is all the more so in light of the seriousness of the charges lodged by the Commonwealth here. As the Massachusetts Guide to Evidence 2024 states, Mass Rule 702 is based on Federal Rule of Evidence 702, while additionally maintaining the common acceptance test. As a result, federal decisions interpreting 702 are particularly instructive. The gatekeeping function of the trial judge under Daubert-Lanigan Rule 702 precepts is of paramount importance. Under the Daubert-Lanigans, the motion judge in her role as gatekeeper has a significant function to carry out in deciding on the admissibility of a scientific expert's opinion. Quoting Lanigan, the reason for this importance was recently underscored as follows. Because Rule 702 grants experts wide latitude to offer opinions, including those that are not based on firsthand knowledge or observations, expert evidence can be both powerful and quite, all of you guys sent me this in Christina Rex's page as well, so thank you for that, can be quite misleading. As such, the importance of the gatekeeping function cannot be overstated. So, and again, the Commonwealth used this same argument against Dr. Russell and the defense. that we can't just let any expert in, because once you tell a jury this person's an expert and they give an opinion, they're so likely to believe it. That said, it still happens in most cases. If you have the right education, you have the right expertise, and you have something that's even arguably scientifically accepted in your community, reliably and accepted in your community, it's more rare that an expert gets struck than one gets allowed in that you think maybe they shouldn't be allowed in. Okay, they got a bunch of citations here. A judge's findings must apply the correct legal standard to the facts of the case and must be supported by an examination of the record. So citing things like that, it's important, it's the right argument, but it's not like Judge Cannone is going to look back and say, oh yeah, I forgot to apply the law. I forgot to apply the correct legal standard. I forgot to take a look at the record before making my decision. That's not going to be something that she realistically admits. The gatekeeper inquiry must be tied to the particular facts. The Polk, Daubert, Lanigan analysis is no different, where, as here, the witness in question is stipulated to be a rebuttal witness. And she didn't put that in her order, if I remember correctly, that she changed the way that she looked at this because he was a rebuttal witness versus a witness they were going to call in their case in chief. I don't think that she made any distinction there in her order. The facts and law in this case are quite similar to the instant case and thus compel the same result. In Clean Concepts, the court stated as follows in response to the defendant's proffer of an expert witness. The defendant has not directed the court to any evidence demonstrating that Sower's methods for determining primary purchasing consideration have been tested, subjected to peer review, are commonly accepted in the field, or have otherwise been scientifically validated. Nor has the defendant made any attempt to demonstrate the Sower's method were reliable independently of industry practices. Instead, it simply concluded, without any citation, support, or further argument, that Sower's worked from a reliable survey methodology. That assertion alone, standing alone, is not sufficient to demonstrate the reliability of Sower's methods. The Commonwealth has postured its opposition to the defendant's motion to exclude Dr. Crosby almost exactly as the defendant did in Clean Concepts. Substitute the conclusory recognized methodology in the instant case with the reliable survey methodology. Like in Clean Concepts, the conclusory and unsupported recognition methodology assertion of the Commonwealth here is insufficient. Moreover, Dr. Crosby does not even assert that his methodology is recognized, let alone does he cite to the literature or otherwise further medical or scientific acceptance of his methodology. And his silence exists in the high-pitched volume of medical and legal literature, calling into serious question the reliability of even known methodologies involving forensic odontologists, veterinarians, medical doctors, and medical examiners, all of which are lacking here with Dr. Crosby. So all of those other sections have issues, but even they at least have certain education, have been allowed in potentially other cases. He doesn't even have the prereqs they have. Based on the potential for appeal, there is a real situation here that the judge needs to consider. She ruled against her own ruling, which said that the witness needed to be a medical doctor to opine on medical causation. So I've answered this question a bunch of times. Just because she said it had to be a medical doctor doesn't mean that is what the legal standard is. But I do think she would be protecting herself to have a Daubert hearing, put her findings on the record specifically as to why she's going to allow him. That's what I think she should do. And she should be confident in her ruling, right? If you're a lawyer, especially a judge, and you feel a certain way, be confident. Put your rulings down in writing. Be very specific in whatever your findings are and let the chips fall as they may. Judges that say, if I lose on appeal, I lose on appeal. I got to do what I think is right and what I think the law says. That's how it should be. The allowance of Crosby makes me think she's afraid of the Commonwealth rather than biased. In that order, what could she say? The extra words allowing Russell were more so justification to the Commonwealth for her decision. I don't know that I see it the same way. I don't think I see it the same way, honestly. This case has so many issues. Realistically, do you think they have a real chance on appeal? I know statistics say no, but it seems plausible here. I would say they do not have a good chance on appeal, but I would say they have a much better chance on appeal than your average case, which is like less than 5%. But they're still far less than 50% if this case were to go on appeal, which is why you don't want to be on appeal, because the chances are you're going to lose. Drea, the black box would have the info that shows a collision, whether the airbags were deployed or not. Yeah, but nobody's saying the airbags did deploy. So there are certain things that the data picks up or the black box picks up, and there's certain things that they don't. It depends on the type of accident. And both sides are basically trying to use the data they got from the Lexus to show their version of the events being true. Brinny Daydream. Your channel helped me drag myself through my last year of law school, passed the bar last year, currently practicing. I owe you big time. LOL. Thanks, lawyer. Well, Brinny Daydream, welcome. Welcome to the crew. I'm glad you're here, and I'm glad that you were able to make it through. That last year can be tough. I remember my first semester of law school were my best grades, and I just tried to hold on till the end. I started working, getting different experiences, was on mock trial, moot court. I loved it, but you're right. That last year of whatever senioritis is, it's like times 10 there because you're ready to go out, work, make some money. And Brennan took his Facebook page down before his appointment. He was friends with Jen McCabe's best friend. Turtle Boy took screenshots. Oh, the sleuths in this case, I'm sure. Emily, this is so off topic, but what if Bev doesn't have an evidentiary hearing on the motion to dismiss? The juror's dismissal without further inquiry seems really sus on her end. Could the defense bring this up later? I don't know what you mean by bring this up later, but anything that the judge does that they think negatively affects the trial in this case and that they think is legally wrong, they can bring up later as an appellate issue. But again, like I said, there's so many, so they have to pick what they believe to be the best appellate issues. That's what they have to stick to. Can PD's orphanage for wayward methodology. Peter, did you get my email a while back? I get a lot of emails, so I'm not positive. You got to be more specific. Nina, and the 3 dismissed jurors were raffled, but never by their names or numbers, only where they were seated. All 3 jurors were pro Karen Reed. So I don't know that to be a fact that all 3 jurors were pro Karen Reed. I know that there were some potential suspect actions taken when they were removed. I don't know that they were fleshed out enough. I don't know if, looking back in hindsight, we would ever get enough information to actually prove that there was something suspect going on there. I hope that everybody's antennas are up for trial 2 and that the lawyers fight hard on the record to make sure. I think they did last time, so I'm not saying they didn't do it last time, but I've heard a lot more information recently from even people closely connected to the situation that have shed some negative light on exactly how all the juror dismissals were handled, and it was potentially inappropriate, and picking of the foreman, but I just don't have enough details that I feel like are confirmed to get behind really what could happen with that. The judge is moving like she's part of the Commonwealth's team. Once Karen convicted, then Karen can deal with all her biased rulings on appeal. Terrible. Yeah, I don't like, I said before, I like when a judge says, well, if I lose on appeal, it is what it is. I want a judge to take it seriously and not think they're going to lose on appeal, obviously. But I want a judge that's confident in their rulings. If you just say, oh, well, I'm going to do whatever I want because I don't care if I lose on, or if I get overturned on appeal, that's not good. And that's not realistic. Judges don't like getting overturned on appeal. All right, let's get back to reading here. Likewise, the March 6th order does not state any evidence of how or where the purported recognized methodology of Dr. Crosby is generally accepted in the relevant medical or scientific community, nor does the March 6th order analyze any of the 5 Daubert-Lanigan factors by tying them to the facts of this case or otherwise cite support in the record of the motion for how the unsupported mold measurement methodology of Dr. Crosby is reliable. So again, they want them to go factor by factor, tie specific facts in the record. The defendant respectfully submits that had the court performed the entirety of the gatekeeping function with reference to the motion record evidence, it would have had to have come to the inexorable conclusion that the mold measurement methodology employed by Dr. Crosby in coming to his opinions about the medical cause of the wounds to the right arm of the decedent was completely unsupported and thus not reliable. Ooh, Judge Cannone could say that sounds like a challenge. They're like, yeah, you would have no way but to see it our way, Judge, after you hear all this. It's kind of like when you hear lawyers saying the only just verdict, the only verdict that the evidence points to members of the jury is guilty or is not guilty. And then somehow the jury can disagree, but they still make the argument. Did I already read? The Commonwealth has had 4 chances to enter the methodology proffered by Dr. Crosby to a study or other form of common acceptance or otherwise satisfy the Daubert-Lanigan factors. Yet it has failed to do so each time. This failure is not an oversight or a mere happenstance. Rather, it is because the methodology of Dr. Crosby is not generally accepted in the relevant medical or scientific community and cannot satisfy the apt Daubert-Lanigan factors. Thank you, Susan, for gifting 5 memberships. The defense continues to be confident. This is Mr. Alessi. We're going to read his affidavit as well. Reed's bite is bigger than. As an RN of 30 years, there are specific regulations that must be followed. Medical causation can only be decided by an MD. Otherwise, is a criminal finding of practicing without a license. So what I will say is medical standards and legal standards can be different. What happens in real life versus what happens in a trial court can be different. And I happen to believe a biomechanical engineer who can talk about body mechanics and how a body moves in a car or after being hit by something, in my opinion, could be able to look at injuries and say whether or not it's possible that the exertion of this force would be possible to cause this injury. I have seen that happen in cases before. We've used evidence like that before, so we can agree to disagree. Piney Woods, Law and Crime. From a trial and appellate attorney for 30 plus years, this case is foundationally flawed. So many ways that the Commonwealth should not try it again. The substantive and procedural errors at Legion. Here's what I'll say. I agree. Foundationally flawed. So many issues here. But we've seen cases in the past. I was just talking, about Menendez, who from one trial to the next, so many rulings can change. The evidence can completely change. But once somebody's convicted, it's over. And everything goes away from a hung jury, which happened in the first Menendez case. And now how everybody thinks about them. Think about how, and not everybody was around, including myself, I don't think, when this happened. But after the first trial hung jury, everybody's like, oh, these poor kids, what happened to them? They're innocent, or this is self-defense, whatever. And by the time second trial came around and after they get convicted, now forever, everybody's been like, oh, they're convicted killers. And so perception can change. And after you get convicted of a crime as heinous as this, the way people look at you and the way appellate courts look at a case can be very different than how they look at it right now. So I will just say that as just a reality. But continue to push, continue to shine a light, continue to call out the issues that we see as we go is important for all of us to do. All of us can do it a little bit differently. All of us see different issues. All of us don't see the same issues as being maybe as loud or disgusting about in the way that you describe them, or the way that you want to hate on every single person that may have a different opinion as you, or to attack them and call them names and say they're stupid, or they must not see, or they must be blind, or they must be corrupt. It's like everybody has their different way of calling out corruption. And I encourage people to call it out and fight for justice as much as they can. I encourage people to do it as graciously as you possibly can. I think you catch a lot more flies with honey than you do with vinegar. Brisby, doesn't an appeal just mean another Bev trial? Potentially a new judge if they win on appeal, but it goes up to an appellate court. She's not making the appellate decision. Will they provide proof it's Chloe? I assume they will have to do that. I don't think Chloe is going to, you're talking about if the molds come in. Yeah, I would hope they would have to provide proof that it is. We haven't seen that in the filings. At least I haven't read any with what the background of that is. Commonwealth said they are only calling Crosby in rebuttal. Do you think that makes a difference for judge allowing him to testify? It could, but I don't think it should, number one. Number two, she didn't say that it did in her order. So I'm going to assume that it did not. Can the defense ask for more time in closing? Yes, they can, but I don't know if you're saying, is there a reason that they should be able to because of this motion? Off topic, will you consider looking at William Brock case in Ohio? Well, Kathy, let's ask the crew, the chat, everybody listening. If you want to know about this case, let me know and I will take a look at it. You can hit me up on Twitter, Instagram, or YouTube in the chat. I am one such medical doctor parachuting in. If Karen Reed is found guilty in trial 2, can issues from both trials be brought up for appeal? Seems there are more from trial 1. Love your channel. So the double jeopardy issues, the fact that the case should have got dismissed for prosecutorial misconduct, I think are things that potentially could be appealed up. But what was testified to in the first case or an objection that was overruled in the first case is not going to be an appeal if she loses the second case. Dubra, I'm also not an appellate attorney, so appellate attorneys may be able to fine tune and look into one thing that could have been used in the first trial. So I would defer to an appellate attorney. But from my experience, that's what I think. In your opinion, do you think Fanning should have been in charge of the security? No. It feels like that was a complete conflict of interest, in my opinion. He was Proctor's supervisor. If I was the Commonwealth, if I was Fanning, if I was a cop, I'd be like, no, I just can't be anywhere near this. Even if I didn't do anything wrong, even if I have the greatest record and I'm an upstanding cop that everybody loves and trusts in the community, that's how you build more trust. Hey, guys, I've got a good reputation. I don't want to sully it by being anywhere near this case because I was involved in the investigation. I don't want to be anywhere near witnesses, jurors, people outside, protesters, supporters, whatever you want to call them. I don't want to be anywhere near it. That's what I would have done. By saying it's not Chloe, isn't that still saying it still could be a dog? Yes, but he says it's not Chloe or another dog or animal. Just like the defense says, could be Chloe, could be another dog. Okay, so we are agreeing to disagree. So let me put it to you this way. Oh, wait, hold on. I see you have another comment here first. The legal standard for medical causation to a degree of medical certainty is clear. Right, but if you notice in this motion, and if you notice in certain things that they testify to, it's medical certainty or scientific certainty. And here they say medical or scientific certainty, even in this motion. A layperson, not a medical expert who can legally diagnose, cannot opine on medical causation to a degree of medical certainty fact. So here's what else I will say. We have had experts that have degrees, doctorate degrees, and otherwise, that are not medical doctors, that have testified to things to a reasonable degree of medical certainty or medical probability, depending on the jurisdiction. I want to say one was an ARNP, was a nurse that had a doctorate. There was another one I can think of to certain things, right? Not always causation of injuries. I'm just thinking, as a lawyer, in every different way that you could possibly use it, that I believe it has happened in our judicial system in the past. Now, medical doctor is best. Medical doctor is what we always want. Medical doctor is what we go for, right? We're just having a full discussion here. Let's continue it. So we're agreeing to disagree. So let me put it this way. Do you think a dog behavioralist can opine on a medical causation of an injury to a person's arm? No, I don't. Okay. And that's not what I'm saying here. So just because we're discussing things and I'm looking at it from different angles doesn't mean I think Crosby is the right expert for this. Was I surprised that Cannone let him in? No. Would I have let him in if I was the judge? Absolutely not. Mostly not just because he's not a medical doctor, but for the reasons that they spoke about here. If he had a good methodology that was scientifically accepted in his community, it was reliable, and it checked all the Daubert boxes, then I may consider, even with his education and expertise, I may consider him testifying. But the defense was right to focus on this prong because this is the prong that just makes him overwhelmingly fail. All right, let's read this last paragraph here. Under Daubert-Lanigan and Commonwealth v. Polk, respectfully, the court is duty-bound to fully exercise its important gatekeeper function by examining the record and making what can only be one finding: the failure of a reliable methodology by, and thus the exclusion of, Dr. Crosby on the papers alone. So that's what they want again. They're going to take a second shot at the papers alone. They're not going to win on that. Any testimony by Dr. Crosby at trial and his unsupported mold measurement methodology would seriously mislead the jury into believing his methodology is based in science and is reliable. And that would be the judge's fault as much as anybody else's. Because she is the gatekeeper, to allow something unreliable in would be her fault. That's what they're saying here. Nothing could be further from the truth. And because the issue of how the injuries to the right arm of the decedent is a key issue for both parties, his testimony with the sponsoring imprimatur of the Commonwealth would be extremely prejudicial to the defendant. In the alternative, at a minimum, an evidentiary hearing on Dr. Crosby is compelled. So even if we don't win on that, we should get an evidentiary hearing. Nina, please join the Karen Reed team as pro hoc vice. They don't need me. They're doing fine. They got enough great lawyers on the team. All right, Dubra, back to this question. Thank you for all you do. Do you think Judge Cannone will reconsider based on her past rulings? So I will lean no. I definitely think, I'm very confident she's going to say absolutely no to just ruling him out on the papers. I think there is a maybe chance, and I hope that she does allow for an actual Daubert hearing or voir dire of this witness. I really hope she does. Basically, every time the Commonwealth has asked a voir dire a witness, she's allowed it during the first trial and after the first trial. So if a lawyer really and how it is in Florida, and we deal with Daubert, and we have the same federal rules here, when a party really requests a hearing, usually a judge gives it, unless it is so obvious and not a close call at all. Usually a judge will give that hearing. So I'm going to say, hopefully, I think that she does need, or she is going to allow them to have a Daubert hearing on this issue. You say there are differences between legal and medical ideologies, but is that not a problem? Medical probability and medical certainty are two different things. My question is there a problem with the legal truth? Well, so I'll tell you, our standards have changed. It used to be certainty and now it's probability, but other jurisdictions still use certainty. In my opinion, this is a thought exercise for us to talk about. If I'm being completely transparent and honest with you, I don't think it makes a difference to most jurors. Not all jurors, some jurors it does. But if I tell you something to a reasonable degree of medical probability and medical certainty for the doctor to stand on the stand and say that, I think most jurors believe them, whether they say probability or certainty. I really do. I could be wrong about that, but I really do. And I think there are always issues. I mean, I've got a lot of issues with the differences between medical and legal that come up all the time in my cases, but don't have time to really get into all of them now. But I really appreciate the back and forth. I appreciate the discourse. I do. Okay, let's get to Alessi's affidavit. I'm a partner with the law firm of DLA Piper. A member in good standing. I make the following statement based on my personal knowledge in support of the defendant's motion for reconsideration. In denying the defendant's motion to exclude the testimony of Dr. Crosby, the court stated in its March 6th order that the Commonwealth has satisfied the foundational requirements of Daubert Lanigan. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. There is an appropriate basis for his opinion in the record, and the proposed testimony, the principles and methodology are reliable. The defendant's objection goes to the weight of the evidence and not its admissibility. Because the Commonwealth has not shown and cannot show that the mold measurement methodology, it's like a tongue twister, of Dr. Crosby is generally accepted in the relevant scientific or medical or scientific community, because if he could show at least scientific, I think, they would have a better argument, and cannot satisfy the 5 foundational factors identified in Polk or the apt Daubert Lanigan factors, and for other reasons discussed in the accompanying motion for reconsideration of the March 6th order denying the defendant's motion to exclude the testimony of the Commonwealth's witness, Dr. Crosby, the defendant respectfully requests that the court reconsider its March 6th order and exclude the testimony of Dr. Crosby. In the alternative, the defendant requests that the court convene a Daubert Lanigan evidentiary hearing on Dr. Crosby. Defendants reserves all and does not waive any argument or right about other failures of the Commonwealth to meet its burden of proof regarding Dr. Crosby, such as the lack of requisite qualifications of Dr. Crosby. Signed on March 12th. Okay. I'm going to read a couple questions, and then we are going to get to Proctor's family statement, which I'm sure you guys are going to have a lot of questions about. Reed's bite is bigger than. I'm not trying to be difficult. I don't find it to be difficult. I don't mind people challenging me. I think you're doing it in a very respectful way. And I think you're bringing a lot to the table with this discussion. And people may agree with you and disagree with me. And I think that's great. So I appreciate that. This is the way to disagree. I'm just pressing out what we have to fix in our system. FYI, watching your lives, you're awesome. Watching your lives, you're awesome. Thank you so much. I appreciate that. You're awesome too. This is the way to do it, people. Jonna. So Crosby a PhD and he doesn't know how to properly cite references. Sure. Well, it's like he didn't even cite a methodology. That's the biggest problem. My partner is a vet and he would never opine on this. It's like people who care about their licenses usually are more apprehensive about going out on a limb. So I get it. Abby Palmer. I just keep coming back to the fact that the Commonwealth as a whole messed up so much that even if Karen Reed is guilty, they can't prove it, therefore not guilty. People are not going to like that generally. Generally in America, people have a problem with that, but that's what our justice system says. If it's so bad and you can't prove beyond reasonable doubt, or it's so sullied that we can't trust or believe anything anybody says, then it's got to be not guilty. Even if you don't think it's innocent, it's got to be not guilty. That's the issue. Okay, here we go. I'm going to read it. I have it just like pasted here. Here's the full release below. So it's some statement, some discussion. In light of the egregiously false statements from Karen Reed and her defense team, both inside and outside the courtroom, Michael Proctor's family is speaking out for the first time to address the ongoing misrepresentations of his character and calling for the public to actually look at the facts of this case. As if the public is not looking at the facts of this case. Yes, everybody hit the like button for the Proctor statement here. So first off, I think everybody is looking at the facts of this case, or at least trying to. We may not agree on the facts, right? Even a lot of us in here may not agree on the facts, but we are definitely looking at the facts of the case. Also, the misrepresentations of his character. A lot of people, and I would not say judge somebody's character based on their worst moments, but a lot of people are judging Proctor based on things he wrote, he said, and he did, right? Not a lot of hearsay coming, at least from in my vortex of what I've been reading, are coming about Proctor, right? It's not like this person's brother, sister, cousin, uncle said this about Proctor, and that's what's bad about his, public opinion. On January 29th, 2022, 14 minutes before his on-call shift was due to end, Michael Proctor was assigned to an unattended death case, and his life was forever changed. Okay? I'm going to do my best to be respectful through this comment, first off, because I do feel bad for his family. They're probably going through it, and it probably sucks. And if it's your dad and husband and brother, somebody you love and you've grown up with, we got to understand what it's got to feel like from their perspective, okay? But he's doing his job. at the end of the day. It's not like he went in there to fight a fire and he's a cook, right? It's like he was a cop and he did his job. He was a lead investigator and he investigated a crime, purportedly. Proctor and the other investigators followed the evidence, and a jury of the defendant's peers indicted Reed. They always go back to the grand jury. And again, if she gets convicted, you better believe everybody's going to take a victory lap. Everybody is going to take a victory lap that believes she's guilty if she gets convicted. And everybody's going to be sitting over here that thinks she's either innocent or there was nowhere near enough to prove not guilty. And it's probably not going to change a lot of people's mind. It really is not. So to act like there's only going to be one way to see this case, depending on, and even if she's not guilty, right? Even if it's a not guilty verdict, people that are going to say she's innocent are going to take a victory lap. People that are going to say she's guilty are going to say the defense attorney sullied it up so much, somebody paid for a juror, whatever it may be. That's what's going to happen. So just be prepared, as Scar said. Despite this, the family says Michael Proctor has been defamed, maligned, and falsely labeled corrupt by the alleged killer, her family, her defense team, and a mob of her followers. Through unrelenting propaganda and disinformation, the defense is trying this case in the court of public opinion and painting Karen Reed as the victim with the hope of tainting a jury pool. And here is our first quote. At the end of the day, a beloved police officer, an honorable man, was killed. The prosecution believes it's an open and shut case. Well, if that's all it took, there'd be a lot more people convicted, right? And the defense knows this too. The prosecution believes it's an open and shut case. The defense knows that the prosecution believes that, or the defense knows it's an open and shut case. I couldn't tell based on the grammar. So their tactic is to put my husband, the lead investigator, on trial for sending texts on his personal phone to his friends and family, said Proctor's wife, Elizabeth Proctor. So here's just a little response. It's not just the defense that thinks Proctor is problematic. It's the public, fine, whatever, throw us out because we don't really matter at this point. The jury found Proctor problematic. They didn't know Proctor. They heard arguments, they read text messages, and they saw him testify for hours. But lastly, the prosecution team doesn't love Proctor as their lead investigator. Lead investigators usually go first, or they're a main proponent and highlight of the trial. They testify about everything. They connect all the dots. They introduce us to people. We should like them. We should trust them. We should want them fighting for justice for us. If you're the lead investigator in the case, he was as hidden as a witness as I've ever seen in a major trial like this from the Commonwealth, which to me tells them how they viewed Trooper Proctor, at least trial one. Maybe Hank Brennan will do it different. Maybe he'll be the first and most important witness. Who knows? Another quote. The Karen Reed defense team is unabashedly creating false narratives and distracting the public and potential jurors from clear-cut evidence. Now, is the defense fighting out in the public for their client? Can people say that they are creating narratives and distracting the public? Whatever, okay? People are going to say that about defense attorneys in a lot of cases. I think that the defense attorneys believe what they're saying. I think they're saying things that they believe to be facts. But to say things like there's clear-cut evidence, I'd like to know what is clear-cut. What is clear-cut? Because there are certain things that are clear-cut. I think the fact that Karen Reed was drinking that night is clear-cut. I think the fact that there were a lot of people at 34 Fairview is clear-cut. Where they were before, clear-cut. It was snowing outside, clear-cut. But there's a lot of things that are not clear-cut. How did the injuries get there? How did the body get there? What time did the body get there? Why did nobody see the body? How did Karen Reed get home and log into the Wi-Fi at this point? How can we not have any pictures of the damaged taillight that's better? Why is the video at the Sally Port so bad? And on and on and on and on. That is far from clear cut. I don't really care who you are. You can say it's evidence. You can say you use it. You can say it could be enough to convict because it might. It was enough to convict for some of the jurors in the last trial. But to dismiss people that don't think or that look at this a little differently, I try not to do that, right? I try not to do that. I try to listen to people that see it differently than I do. It was recently announced that all aspects of this is not a quote anymore. It was recently announced that all aspects of the federal investigation involving this case have been closed. Michael Proctor, who has an unblemished police record in his 12 years with the Massachusetts State Police, testified that the texts on his personal phone were unprofessional and regrettable, but certainly didn't affect the integrity of the investigation. And this is a scenario where people make mistakes. And I get it that you make mistakes, but there are consequences to your actions. There are consequences to your mistakes. And from my perspective, a consequence to those texts is it's hard to believe that you didn't have any personal feelings that may have been clouding your judgment or clouding the way you thought about this case or investigated this case. I think a reasonable person can think that. And to dismiss it and act like that's not a reasonable inference, I just think you're asking for the criticism that's probably going to come from this. I'm not going to criticize them personally because I get it. They're in a tough position. But when you say stuff like this, you have to realize that's coming. Reed's Bite. I care about my license, but I will always speak the truth. I get it. Can't speak the truth. Shut up. I get it. And I was talking about the person that said their vet husband wouldn't do that. Body marks. Isn't this a violation of the gag order considering Proctor is part of the prosecution? I'm sure Reed or her team responding to it in any way would. Yeah, I mean, definitely Reed or her team. It's Proctor's family member. That's why Proctor didn't make the statement. That's why the Commonwealth didn't make the statement. You're starting to get a couple degrees separated. To me, this ain't even worth filing the motion on, my opinion. But if Hank Brennan says anything about, one side going out and using the media, then I think they can make the exact argument that you just made in your comment. Entire case is a gamble for every single witness, lawyer, police, and judge. Everyone on both sides needs to go all in reps, careers, and future. It is definitely important. Nixon, don't feel bad for his family. His wife and sister who wrote this have been calling people's employers to get them fired. And I just feel like, I don't know if this is true or not, but people that do this to each other should kind of shouldn't be surprised if it happens then coming back, right? It's almost like the treat other people how you want to be treated principle. Do you think that the family is speaking out because the federal investigation is over? Would it have been detrimental if they did before now? So I have no idea. It's total guess, but maybe they weren't so sure if he was involved in the federal investigation, so they didn't want to make matters worse, and they felt like this would bolster their position now that the federal investigation's over. I have no idea. Because the internal affairs situation is not over yet, and they came out and made a statement. So it's not like they were waiting for everything to be over. Proctor is saying Karen Reed defamed him while the Commonwealth is pinning all their sins on him. Not sure it can be both. Exactly, Abby. We heard what Hank Brennan said about Michael Proctor. B, the same guy who was looking for nudes in Karen Reed's phone. People have a problem with his lack of professionalism. He has to be held accountable. Yeah, I mean, I do not feel one bit bad about saying Proctor was not doing his job, was doing a disservice, was getting paid by the people of that jurisdiction, taxpayer dollars paying him to do things that are completely inappropriate. Let's read again, because I have some more comments on here, the excuses they make for him. Michael and so many others in his line of work see horrible things every day and may at times need to vent personally. I've got a lot of friends that are cops, a lot of friends that are firefighters. It's very difficult stuff. You see horrible things, right? Doctors do too. Lawyers have to deal with some horrible crap too. You cannot speak like this about somebody you're actively investigating, where there's an open case, where you may have to testify, where these people you're talking to may be involved. You can't. That's professionalism 101. And this is not an excuse. I have some difficult crap that people talk to me about, right? Nobody ever calls me with good news. I always say that to people that call me on YouTube. They're like, wow, it's so great to talk to you, but it sucks I'm calling you under these circumstances. I'm like, yeah, nobody ever calls me and is like, hey, I want to hire you to do something good for me, because that's just not really the business I'm in. And I get that. I chose this life. This life chose me, right? But to act like, to give this excuse, at times you need to vent personally, to me, opens up, and this is a quote, by the way, opens up that he can do it in the future. There's nothing wrong with it. They got to vent personally. They got to blow off some steam. Maybe you're not fit to be a cop. Maybe you're not fit to be a firefighter. It's not like I would ever say, oh, this John Smith case I have, let me tell you about this client. He said X, Y. I would never do that. Do I have thoughts sometimes that are maybe inappropriate or bad about a case, about a defendant in a case of mine, about a judge, a lawyer? Sure. But you've got to know not to do stuff like that. You just have to. As a cop, you're held to a certain standard. And you can't make excuses, because then that's going to allow it to happen in the future. Back to the quote. He saw a fellow officer die a horrible, tragic death. Who among us has not said something regrettable in moments of stress, shock, or sadness? I agree with that. We have said things that are regrettable. That doesn't mean there are no consequences to what we said. We can apologize. We can ask for forgiveness. It does not mean there are not going to be consequences. And if we say something and we know it's wrong, we apologize, that's one thing. But what are our actions afterwards? What are our comments afterwards? What are the actions that were going along with these comments that were being texted about? And how would you feel if the texts of your personal phone were questionably released to the public without full context? So questionably released, I know there's some discussion about that, but if they really were inappropriate and not reliable and shouldn't be used in trial, I think we can all agree Judge Cannone would not have allowed it, right? That was a quote from Courtney Proctor, Michael Proctor's sister. Bev wanted the metadata for AJ's email, but not for all the Sally Port videos. Are we in the era of AI generated videos and they're allowed in court? Oh, it's going to be a scary time. And I feel like, I'm reasonably young for a lawyer and that stuff is still difficult for me. Reed's Bite. I do not feel bad for Elizabeth Proctor after reading that statement. I did prior, not now. My God, to even put out a statement like that, it is so out of touch and not truthful, such BS. B&B. Hi, Peter. Sorry, not to screw Proctor and his family. Also, but screw Proctor and his family. Also, glad the defense is fighting back with anti-Bev's motions. Ashley King. How much more money would it really cost for a new judge when there's a mistrial by hung jury? Wouldn't it cost more to make the same mistakes twice? Yeah, I don't think that's the main reason they're not booting her is money. I think she doesn't want to recuse herself. And at that point, that's why she's staying on. There would have to be a reason to replace her at this point. Emmy, is Crosby as rebuttal a strategic move so he can be last and not rebutted by ARCA and closer to deliberations? I think they don't want to bring him up until they see how Dr. Russell does, and then to rebut Dr. Russell's testimony, that would make more sense. I also think Brennan, if I had to just guess, right, he is not going to spend most of his case defending the McCabe's, the Alberts, defending the dog bite. I think he's going to spend most of his case in chief proving Karen Reed did it, right? That's what he thinks. That's what he believes. I think that's what he's going to do. And then I think he's going to have a longer rebuttal defending the McCabe's, the Alberts, Chloe, etc. How do you have Karen Reed's medical information less than 24 hours after J.O. died? How? I think that's a rhetorical question. My biggest problem with Proctor is the pin it on the girl text, lack of evidence logs, evidence not getting processed for weeks, and forcing ME to make change to the death certificate. That's what I mean when I say it's not just the words he texted. It's not just a personal group chat that's uglier than we ever would want it to be. And it's not like none of us have a text message we wish would not be aired publicly. But it's those texts with comments he made to other people, with actions he took in this case. Bev's rubber stamp. How can any of the Sally Port be admitted to the court? March 2022, as well as the court February 2022, ordered all videos, photos, and metadata be secured. Reed's Bite. Peter, as an attorney, do you not think that there is, for the line situation, i.e. calling people's employers legally, really, is open this an excuse? I completely think there's a line that has been crossed. There are so many lines that have been crossed on this case by lots of different people. And I wish people would stop crossing those lines. I think we can have a discussion, disagreement publicly. And I think that we can push for transparency and justice and fairness in the court system. And I think we can stand up and peacefully protest when we think it's not there. I think we can vote certain ways to try and make it better. And that's what I would say is the way to go, not calling people's employers because they disagree with you. Proctor's wife says the family has been tormented for years because of this case, and it's time to focus on the real perpetrator. Unfortunately, we know that by speaking out, more harassment will be unleashed on our family. So that's tough, but you're saying things to more than just Karen Reed. You're saying things about Karen Reed, about her lawyers, about the mob that she has, about her supporters, about people that think Proctor is corrupt, right? There may be people that think Karen Reed's guilty, but still think Proctor's corrupt. I'd be willing to bet some of those jurors that were going to vote guilty were like, yeah, that guy is not a good cop. And it's not just because of some spin or some false allegations or because somebody's lying about him. They heard the evidence and they listened to him testify. So we just got to be careful about what we say and what we welcome, right? Apologies don't matter. If someone says something and many people hear it and then the apology comes later and no one has it, it doesn't matter. Jessica, I'm a firefighter medic of 18 years in an all-male department. That seems to be the norm. I've never heard anyone speak remotely like Proctor. Disgraceful. Yeah. I would tend to agree with you. I've seen some stuff I wish I never saw from some friends, but can Bev go before an ethics board after? I mean, if she's reported and they find issues potentially, but not just generally because somebody disagrees with her order. Can they sequester the jury this time? I haven't heard for anybody asking for that. I would be interested in which side would want that. Pin it on the girl. Shut up, Mr. or Mrs. Proctor. End of story. Go away. Crawl into the hole. Never come out. Proctor's everything bad. Okay. All right, Crispy. Tell us how you really feel. All right. Let me get to the last part of this last quote. But we can no longer stand by and silently watch Michael's character be attacked and disparaged so unfairly. After exhaustive investigations at both the state and federal level and a grand jury, only one person has been charged with a crime, the defendant, Karen Reed, said Elizabeth Proctor. So once again, we don't know if internal affairs, if there's going to be any wrongdoing found on Michael Proctor. If there is, that would change the vibe of this a little bit, even if he didn't commit a crime. We're discussing wrongdoing. And again, I don't think this comment or statement by Proctor's family is going to have the desired effect if I had to guess. Does anyone wonder why states like Massachusetts appoint a judge, I think is what you mean, have concerning outcomes against their citizens? Appointing judges adds to corruption fact. I prefer voting on judges. That would be my preference. That's what my jurisdiction does. Danielle, but there are obviously judges appointed from time to time by the governor and the president federally. I was underwhelmed with the defense's case when the Commonwealth was done. I wish they reiterated their theory during trial 1. Do you think they will do more / take more time to recall more witnesses in trial 2? I would hazard a guess that trial 2 is going to look very different. Facts are the same, right? At least the main facts are the same. The allegations are the same, but I think the presentation is going to look different. I do. Nina, I understand that the whole AI issue is difficult for you, but it's real and it's scary, especially if a judge allows videos without metadata. It's giving them a free ticket to create AI videos. So they really there needs to be good experts, right? And the experts need to be able to point out and explain to a judge in a scientifically reliable way as to how do we know if it's AI, if it's been doctored, etc. Captain Trips, bad judges and bad DAs equal bad cops because they all cover each other's butt and no one can do anything when it goes so high. I agree. When they're in cahoots together, and then it almost encourages bad behavior. And a lot of times it starts by, we're doing this to get the bad guy. We got to break the rules to make sure we get the bad guy. And that's why it should never be allowed in that situation. Even if we know somebody's a bad guy, we shouldn't let the rules be broken because it creates this systemic problem that it's so hard to get out from under. Thank you, Carrie, for gifting a membership. All right. 1 hour mark is here and we are done. I love when a plan comes together. So thank you guys so much for joining me. Make sure you hit that like button if you have not already. But that's all we got. Until next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.